hear this? No. Okay, and I'm going to hit record. Go ahead, take it away, Steve.
Okay, actually, because we're getting more people than I thought, I wasn't going to speak for an hour and then do questions. I'm just going to have people interrupt me at different points. I have to say I'm a little distracted. I'm sort of a part-time municipal judge, and the county lets me bring my dog, and it's great. And there's a plaque you get. And it says municipal judge parking, and it looks like someone went in my car and stole it. And now those people are going to be parking in front of the meters that say app and a fire hydrant in front of the courthouse. I mean, if they wanted one, they could go to the Scarity flea market and buy one, So, all right, I'll have to deal with that. But okay. Number one, I do not speak for the State Bar of Texas. Okay, that is only the executive director or president. So I want to make that absolutely clear.
So, Steve, you're coming in and out. Your picture, I don't know if you could. If we could get you fix that. Yeah, it's just coming in and out.
I think she means just space yourself out a bit, get a little bit away from the the camera. Maybe face the camera down a little bit. There you go.
Okay, good. That's my Washington place in the background. Okay, so I had to say that. Now, this really is a discussion. I'm not smart enough to speak for an hour and a half on anything, maybe pistachio farming or endangered trees or stuff. But so I'm going to tell you pretty much, give you sort of an outline. And then, when it comes to the topic that you may be interested in, please jump in. And I specifically invited a lot of people who disagree with me. So we did this before. It was very friendly, all sorts of opinions. The hour and a half is just sort of an estimate because we had an hour last time we did this a few weeks ago. It went to an hour and a half. But if you guys don't participate, it's going to be like a 15-minute CLE credit. And that's probably not what you want. Okay. So what I'm going to talk about a little bit about the decision that's been discussed a lot, and some of the things that were brought up, like political activities, Office of Minority Affairs, same-sex marriage, aliens, access to justice, political activity of the bar, opting out from dues, and then I'm going to play a little of the Fifth Circuit opinion, free speech. I'll talk about a couple of other state bars, and would definitely want your input there on what the bar should do. And then some of the reform topics like that I've been pushing, like Zoom and grievance reform. So really get my attention or get Ruben's attention and let's go. The first thing I'm going to do is read the last part of this opinion. There's been an update a couple of weeks ago. The case was remanded, and the bar was ordered to pay costs. Okay, so that's not in the materials. There should be a copy of the opinion there for you. Okay. So the final part of it is the district court erred in its reading of Lathrop and Keller, and in its application of Keller germaneness test to the bar's activities. We therefore vacate the summary judgment that the bar got, render partial summary judgment in favor of the plaintiffs, and remand to the court to determine the full scope of relief to which plaintiffs are entitled. I'm going to play you just the first bit of this, and you can hear the plaintiff's argument. And I'll show you some of the bar's argument. I'm not going to play too much of it. I've also given it to Ruben so you guys can hear it. So this is how they start.
Claims at issue in this case. I think it's important to start with two broad principles that cut across all three claims, and I think have to inform the court's decision on all three issues. So the first is that The strong and overwhelming default rule is that government cannot compel association or subsidization absent what the Supreme Court has called extraordinary circumstances. The court's quoted Jefferson several times, who said, "To compel a man to furnish contributions of money for the propagation of opinions which he disbelieves is sinful and tyrannical." So first big principle, because compelled funding and association is the exception and not the norm, the Supreme Court is clear that if there's any ambiguity, if it's close, the court has to err on the side of protecting the First Amendment rights, because of course, the bar has no First Amendment right to anyone's money or association, but my clients have significant speech and association rights in their own freedom of expression and association and conscience.
Okay, there we go. And so let's go over some of the things that were discussed. And once again, this is your opinion, and I want to hear it. And my opinion, I might give you my opinion, but it's really irrelevant. The first thing is the political activities of the bar. You know, they're saying that the bar can only do things that are germane to administrating the practice of law. And then there's all these complaints about political activities. And you'll see on some of these things, I agree with the bar, and some of them I don't. But let's look at a couple of them. It was mentioned that the bar has an Office of Minority Affairs, and that spends $500,000 a year. The total bar budget usually is $50,000, 51, 52. It's down to about 51, 52 million, and it's down to about 43 million. So a few people are saying they don't see the materials, Ruben. If there's some way you know how to post them, you probably know this better than me. So let them have that.
Everyone, we're going to be posting it on the Facebook site, and then we're also going to be emailing it. And let me try and see if I can share it at least on this chat.
Okay. So the Office of Minority Affairs is there to look for employment and economic opportunities for minorities and women. Does anybody or do people think that that's a decent expenditure of bar funds, of your dues? And there's any opinion?
No.
Huh? Who said that? I thought somebody said no. And
If you're gonna ask something, please say your name. That way we know who you are, and then ask your question.
Okay. In my opinion, just my opinion, it is a reasonable expense. I would like them to monitor it and see what the opportunities have been for minorities and women, but I think that's not too political. Once again, I know there's people in here who disagree with that. So say it. The other thing is the bar was sort of mentioned in 2019 legislative agenda for LGBT rights and promoting that in the legislature. Now, is that something that your bar dues should be able to go for? Once again, I'm not. Who's talking?
That's too much. You're into.
Okay, I can't hear
I think
that.
somebody just was unmuted.
Oh, okay. All right. Once again, the Supreme Court in Oberfeld said that same-sex marriage is okay, and if the bar is looking to make that into the law and help codify it, it's probably a legitimate activity. I don't know how much they spend on that. We'll go into budget a little bit later. Okay. Another one is aliens. And the people said, well, wait, these aren't citizens. Why do they get protection? Why do they get protection from, say, access to justice or so? And the argument there is that, we represent people as lawyers that we don't necessarily agree with what they're saying. So that's how that went. Okay. I'm going to go to access for justice and just talk about that a little bit. And then I want to see some questions or some discussion. Okay, the Access to Justice is an organization, and the bar funds a lot of it. And it promotes just what it says. It does some political activities, but it promotes, make sure that people, as many as they can, have the right to have an attorney and can afford it. California does this, and California, there's an opinion July 15th, and California was not nailed for it. And it looks like, in the bar's opinion, that can be okay. I don't want someone just saying, I agree with you, Steve. Tell me. So who can discuss any of these things? Remember, you don't want a 15-minute CLE credit. Is somebody there? Just raise your hand and talk, or maybe Ruben will see you. I mean, somebody has to, you're lawyers, you have opinions.
Steve, this is Alex Wathan. Can you all hear me okay?
Sure can.
Yeah, I'm serious. I'm not making this up. I believe that the grievance committee is an immoral activity because they deprive us of our right to free speech, and they go beyond regulating attorney speech, but they actually have a chilling effect on free speech. And the moment that this and the Boudreaux decision are implemented, I'm going to uncheck them on my check boxes that I know will be required by these decisions. And I don't want any of my money to go to the grievance committee because they deprive people of their constitutional rights. So what are your thoughts on this approach?
Alex, we are going to get into grievances big time. And so, and we'll talk all about grievances. So I'd rather wait for that, but okay. I so appreciate you raising your hand. It looks like you have a llama next to you and offering that. But since you raised your hand, then we have someone else here. Who is that? I can't see the name real well. We might. Is
the iPhone okay?
Is iPhone? Sure, iPhone's okay, but there's someone with their hand raised right next to me.
Would that be me, Jeff Scott?
Yes,
yeah, that's you, Jeff Scott.
Jeff, yeah. If it's about grievance, if we can hold it a little bit, but if it's about any of that other stuff we talked about, let's hear it.
Grievance. I want to know, do I pay my dues by the end of this month when they're due?
Oh, because of what the bar said in that.
Yeah.
It looks like we're going to be jumping around, you know.
I mean, get right to it, baby.
Yeah, the last, and what Jeff's referring to is we additionally reverse the denial of plaintiff's motion for preliminary injunction and render a preliminary injunction preventing the bar from requiring the plaintiffs to join or pay dues pending completion of the remedies phase. So my guess answer is yes, you still have to pay dues. They're talking about the plaintiffs. I see in the chat someone else is about to sue the bar in a class action in state court. So that is, I would say right now you do have to pay the dues. And I'll talk more about that, Jeff. I really will. I have a whole little section on that. Okay.
Thank you.
Sure. I want to get to everybody, and I see Bob Bennett. Bob Bennett's talking about the tax on Larry McDougall. That's for later too. And matter of fact, Larry is going to join us. He's giving another CLE. And then Rich Robbins is saying, anybody seeking a dues refund, please feel free to contact me. Are you guaranteeing that, Rich? You know, that if I write to you, I'm over 70 anyway. Okay, so anything more on access to justice? I mean, is it the bar's duty? Is it our duty as attorneys to support access to justice, to support something like that? Once again, just because I think it may be, that isn't, that may not be your view.
Steve,
so does anybody?
Steve, this is Janine Gorel.
Hi.
I'm in Lubbock, Texas. I do think that hi, Errol. I do think that the bar has a duty as part of our duty to our clients and to the public generally to fund access to justice in the sense of underserved folks or folks who legitimately cannot afford a lawyer. I think traditionally, if there's such a thing as traditionally, that has been an objective. I know the then Supreme Court Justice came and spoke with us in Lubbock at the law school about how it's his objective to pursue access to justice. And I believe, meaning what I just said, in indigent folks or underserved folks. My concern with the new job description that went out is that it seems to be not just helping folks that come to us, but seeking out quote unquote injustices. That may just be the way I read it, but that would be of concern to me. And I'll mute myself now.
No, don't mute yourself. Wait. Now, now that I've got you, and I know you're a fairly conservative person, how do you feel about the bar lobbying for changes for same-sex marriage, let's say, and for having an Office of Minority Affairs? Now, I think the courts are okay with that, but do you have an opinion on that too?
Well, my opinion would be the same as yours. It's been approved by the US Supreme Court in terms of LGBT and Obergefell, and in terms of having an Office of Minority Affairs. I'm unaware that issues having to do with folks who are minorities, and I guess to a certain extent I include myself in that, even though I might not look it. I mean, I'm a religious minority. So I think that that's an appropriate thing, just appropriate, an objective. The question becomes how much, what proportion of our dues go to something like that? How involved do we get? Are we talking about writing amicus briefs? Are we talking about helping, having a walk-in clinic, having a hotline clinic? Or are we talking about people that go over and organize protests? I don't know. There would some reasonableness standard would have to apply for it to feel comfortable to me.
Okay, great. And to answer your question a little bit, the first time I was a director, when I represented the Corpus and South Texas area in Victoria, we spent $2 million out of about $48 million directly on access to justice. There's other fees. So that's good. And it seems like most people seem to agree. Ruth Gomez Sierra agrees, and Christine Mangle, and then Cynthia, okay, and a few more. Good enough. Okay. Now, how much political, next question for everybody, how much politics can the bar do? They're sort of, now that even some advocacy, may not be good. And once again, I'm going to defend the bar on this. It's hard with 106,000 members not to have lawyers or lawyers on committees do some politics. I testified in a committee for, make the election laws a little bit fairer and for insurance. And it came out that my opinion was that conservatives and Texas lawyers are underrepresented and maybe not given the same rights as free speech and to run for office as some of the others. And that percolated through the legislature. But you go to your legislator and they're going to talk to you and they're going to ask you political questions. It's really, I can't blame the bar for some of that, as long as it's not directly costing dues. Once again, that's just my opinion. Looking at page 29 of the opinion, and I don't know if you've all downloaded, I think a few people are having trouble, but they talk about germane opinions. They talk about germane. In sum, the bar engages in non-germane activities, so compelling them to join violates the First Amendment. And that's just a little note that I have and want to make sure that's it. Given that the bar is engaged in non-germane activities and that its interests fail exacting scrutiny, that is a straightforward application of Keller. So what can the bar do? I mean, can the sections go and say, this family law thing needs to be changed, even though it's somewhat political? Does anybody have an opinion on that? I'm getting things on other topics, about grievances. We'll talk about grievances, I promise. Anything on that, any opinions on what politics should do? I can tell you that I'm friends with most of the people who were bar presidents, and I would say 8 out of the last 11 were pretty liberal Democrats, and I would say most of the directors, almost all of them, are maybe a 25-5 split or so. So they do have opinions, and that'll come up when we talk about Larry. Okay. On page 32, I will talk about your bar dues and the budget. And that person, Mr. Scott, I believe, come right back and talk to us. They're saying that the bar's procedures are inadequate about informing people that they can opt out. On that, I certainly agree, because I've been a director for 2 terms, and I didn't even really know about that. I mean, I might be a little bit ignorant, but I didn't know about that. And what is political opinion? I mean, if people on one side, I mean, it's pretty broad. If you agree with if you disagree with the bar's policy and some of the politics on this, you know, you're going to be able to opt out for at least some of your dues, and you do a protest. I think that opens the door, if you really think about that, to the almost voluntary bar. And I also think it opens the door to abuse. Somebody might say, I don't want to pay my $235. Well, they did this and this, and I'm out of there, you know? So I think it can be used unfairly. It has to go to, it has to be done in writing and approved. I don't know, that's a tough one. What do people feel about that? I mean, should, and there's other bars, we could talk about them, and they do everything differently. And what, I'll mention a little bit. What I wanted to, and boy, we're only used 25 minutes, so you're not going to get much CLE credit unless you ask questions, but or unless you make comments. But I wanted to put like a PowerPoint or something and show you all the state bars and what the dues are and what the grievance is. That is not amenable to being done, and I'll tell you why. California might have a $535 bar fee. But if you look at the print, if you make $70,000 or less, then it's quite a bit lower. And if you make under 25,000 or not or so, then you don't have to pay dues. I'm not 100% sure on that. I've been reading all the states and getting them a little bit mixed up. So, that's what you get there. It is mandatory, and the bar said we should look at other state bars. New York. It has something similar, but when you pay, and a lot of these states, the CLEs, you have 3 years, and normally it's to get 25 or 45 hours credit. So it's a little bit different from Texas, which is 1 year and 15 hours. In New York, for example, you pay your bar dues and you get a certain amount of CLE. I think it's, if you pay your bar dues, you get 8 hours free of CLE. So, when you say, let's compare all the bars and see, it's not that easy. And I've asked the bar to do that. I've asked the board to do that, but the board's attitude is pretty much, we're going to try to fix this, and not, one of the things I'm upset at the bar is that they don't want other ideas. They don't want, it's almost like they don't care about what we think. And if you see any of the meetings, they always stop me, interrupt me, make me be quiet, not put stuff on the agenda. So that's with that. There are some interesting things about the California bar. There's 8 California attorneys that are over 100 years old practicing, and there's I think 6 or 7. We talk about 50-year lawyers in Texas. There's 6 or 7 80-year lawyers in California. So that's impressive. And 1/3 of the California lawyers are either inactive or not eligible to practice. So it's not that easy to compare. I don't necessarily say let's do what California does. I wonder if some of you know about other bars. And Paul Robbins says, why not be a hybrid? Can we put Paul on there and unmute? Paul, unmute yourself and talk about that.
Hey, Steve, how are you? Paul Robbins, Bluffton, Texas, highly underrepresented in the state bar. I understand that, and I appreciate my colleague for differing opinions, but it seems like we get blurred when we're going into every special facet of every political agenda. I mean, what are we to do about the state bar? Are we a political organization or are we a professional organization? And it seems like there can be both and there can be dual aspects. I'd like to see my dues go to the mandatory functions of the bar. If everyone else would like, and let's figure out what that costs. And if I want to opt in, just like in any other organization, any other charity, I have the option to support that with my money, my time, and my efforts. So I think the mandatory functions should be funded by our state bar dues, and these extra political functions supported by those financially that support those agendas.
And I see people are agreeing with you. Okay, well, Paul, let me pin you down. What is political? I talked about access to justice. Is that something that should be mandatory and paid for by your dues, or is that something that should be voluntary for those who want to do that? And you're getting.
Well, let me ask you this question, Steve. Do you think it's done effectively?
Go ahead.
Because here's the thing. I agree there should be access. What I disagree is the ineffective way that it's being done. Every day someone comes in my office almost every week and we help people out. We help local businesses. We help local people. We help peace officers. We have emergency management technicians. We provide free services and we give access to people through our law office all the time. Now, I do kind of have a problem that I have to pay extraordinary fees every time I file a lawsuit, or that my Ulta account gets pillaged by the state bar that goes into funding of organizations that I send people to that are supposed to help people, and people come back consistently and say, I don't qualify. And so I don't think it's being done effectively. I do believe that we have a moral and even maybe a legal obligation to provide legal access to people. I don't agree with the way it's being done. So you tell me, is that a political function or is that a mandatory business function of the bar? Because if it's a mandatory business function, we're not being very effective at doing it. We're not reaching out to the community and actually providing those services. I would rather see there be a fund and let attorneys supply those services, turn fee schedules in, and at least get enough to cover their overhead to provide discounted legal services. I think that would be much more effective.
No, that's good. Okay, and my opinion is, yeah, it's not that effective. IOLTA, that's crazy. I mean, it looks like I pay them 22 cents in interest a year. I mean, it's just, I'd rather that. Randy Searles once had a good idea, I thought, that you don't have to do IOLTA if your amount is 2,500 or 5,000 or less. That once again, that's just my opinion. It's just not worth the hassle. Whether we're efficient at doing the services, I sort of agree with you. And of course, a lot of attorneys do pro bono. Sometimes it's not because we want to, but we do. And there's not been any really good studies, and you hit on something there of how well we're doing and how many people are getting help that need help, and what other organizations they can go to. So yeah, I pretty much agree with that. You know, the one thing about the bar, though, that I want to say that's good, that is efficient, is the budget. Now, when we talk about opt out, you know, the court, I agree with the court that how do you find out what's in the budget? I have a budget. You know, I want to know how much money is spent on PR, public relations, because I really resent, once again, my personal opinion, when you write a director's letter, lawyers aren't writing those letters. The PR department's writing it. I can write my own letter, you know, I went to college stuff. They don't like that. And then on this decision, they send out talking points. I don't need to be spoon-fed talking points. I'm not the greatest lawyer, but I can read an opinion and get an idea on that. So yeah, but what the bar is good at, and look at California, is we live within our budget. We have a little excess funds. I think the money's managed extremely well. And I look at California, where 2 out of the last 3 years, even before COVID, they had a big deficit. And then during the year of COVID, where we cut money and cut staff, California had a huge increase in employment and salaries and personnel. So I'm not so happy about California. When we talk about grievance, though, they have something that I think is really, really good. I'm sorry, I keep moving around. California has a statute. Now, we talk about sworn grievances, and most lawyers are for it, but we can talk about that more. California has a statute that if someone erroneously and maliciously files a grievance against you, that's a misdemeanor, and the DA and the bar have a duty to report that. And so we look at maliciously. Well, who files a grievance that's not with malice? I mean, you're not filing a grievance to say, I'm so happy I like this attorney so much. So I like that, and it's something that we should look at. And I just wish the bar and the directors would be more open to other ideas.
Steve, I have another question, unless it's not good for me to say, because I'm not sure I can stay the whole time. You mentioned something that I think is really germane about what studies have the access to justice folks, I'm just going to say folks, done about whether they are delivering service. And one thing in my own personal knowledge, up here at the Lubbock Dispute Resolution Center, where I do contract work, they focus a lot on giving information to pro bono folks. Additionally, I've seen at least one, I think it's a CLE, it might not have been, about that truncated service type deal where you're just writing you're just writing the pleading, but you're not required to represent them in court. I mean, personally, that's not a lane I want to walk. I would love to see, if we're going to actually do access to justice, people truly who need a lawyer can get a full lawyer, not just somebody who's going to write a petition and then disappear. And I don't even think that's lawyering, but that's, again, my own opinion. There are opinions where you can do partial parts of a case, but I think that's an ethically fraught situation.
Yeah, and Matthew Brown scolded me, don't compare to California. And I'd really, and California is good and bad, but that's fair. Is there anybody here that's licensed in another state, or has been licensed in another state, or has researched another state and has any ideas at all about something that they do that we don't want to do, or that they do that maybe we want to do? Has anybody at all been licensed in another state?
Steve,
Rich?
can you hear me?
Yeah, and
Hi,
even
this is Richard.
a lot of people are responding, so go ahead and expound.
Okay. I actually went to law school in Virginia, and I've been studying up on what the Virginia State Bar does. I think this will appeal to Mr. Robbins, who spoke a few minutes ago.
Whoops.
Hello?
Okay. Yeah, I don't know what that's a technical.
Go ahead, continue.
Okay, I'm back. Anyhow, the Virginia State Bar focuses basically on attorney discipline. They don't even really produce much CLE, whereas the Texas Bar gets about 12 million or 13 million a year in peddling CLE. The Virginia State Bar maybe gets 50,000, and that's something they generate for their annual convention. But otherwise, they focus on attorney discipline. It's when the bars, like the Texas Bar, does so much other stuff that no judge wants to oppose the bar, for fear that that bar will use its lofty weight to get that judicial candidate a primary opponent in the next elections. Imagine having a disciplinary defense endeavor in the court of one of those Texas judges or justices. You cannot win. And I've got the data on this. When does anyone ever win in court against the Texas Bar? And it's not because of the lack of merit that these people are losing. It's because of the lack of a defense against the corruption. So the Virginia State Bar has really whittled down its activities. And if anyone would like to know more, my email address is rich@texasbarsunset.com. I'd be happy to hear from you.
Okay, and I'm sure we'll hear from you again, and I want to hear from Bob Bennett in a little bit when we go to grievances, because he's worked so hard in that area. And Robin Bassler says that California Bar does not offer CLE. That's, I said.
Actually, let's, Robin, would you unmute and tell us a little bit what you think?
Yeah, go ahead, Robin.
Thank you. I'm just trying to learn about Texas, how indigent criminal defense works in Texas, because that's my specialty. I work for a large public defender office in Los Angeles, for Los Angeles County. So since that criminal defense is my specialty, I'm just here trying to figure out, just learn the lay of the land. But I don't really know too much about the discipline system in the California bar, and they do not offer CLE. In fact, I was just looking at the Texas CLE page through the bar because I'm taking the Texas law component. I don't think California offers CLE. It's pretty much on our own. That's it though.
Great.
Okay, thanks.
Thank you.
I sort of like the Texas Bar CLE because it offers so many courses, and you can get part of the law library, the online law library. I mean, New York says they have 900 different courses, so maybe they're up there, but Texas has a wide variety, and I really defend the CLE department. Don't worry, I have problems with the bar, and we'll get to them, but the CLE department, and they have scholarships. We worked on a scholarship program where I used to be able to give out these things that you get 50 or 60 or 70% more off any advanced course, any course that the bar did. So I think the bar is good about that. And I think the bar is good about letting us do free CLE. Remember, when we're doing free CLE and you're getting an hour and a half here or whatever there, that's less revenue for the bar. So, I appreciate that department. There's a lot that I don't appreciate, but I appreciate that department. And anybody else think about that, or other states, or what should the bar do? I'll wait and I'll tell you what I think they should do. But what do you think the bar should do?
Do about what?
Just in general about CLE and whether we should we have a voluntary bar? Should we have the bar where you're just paying for the disciplinary stuff? And then I think Paul said that pretty well. And then the political stuff goes separately. I wonder, there was a poll done in 2012 or so, and a majority of lawyers, by a very small 47 to 45%, said they'd rather have a voluntary bar. And since then, the bar, I don't know how people would feel now, but the bar sort of has a fair campaign. Well, if we go to a voluntary a bar, then the legislature is going to kill us, or this and that. And when I looked at other states, once again, it's not complete. I don't know that that's true, but is the bar, we can talk about the bar grievance next, but is that a fair system? Now, some people are saying the SBOT CLE is not cheap. William said that, William Wilson, and but others seem to like it, Jonathan Gluckman. It's not cheap for the advanced courses, but so much of it they let us do for free. So I'm still favorable. You can get, when you're a director, you go to all of them free. And so I could tell the boss hierarchy of which part of the profession they like by the meals. So you go to advanced oil and gas, and they have all these hors d'oeuvres and stuffed trays coming around, and advanced bankruptcy has yogurt and blackberries that they bring you, and civil has a great buffet. Family and criminal, often it says on your own, So I always took that as a barometer of how the bar felt, but there's alternative explanations. Okay, let's talk about grievances somewhat. And here's somebody wants to speak. Warren, is anybody trying to talk? And I wish you would.
Monks, did you want to say something? Gerald?
I can't tell if they want to talk just because they show up on my screen.
Paul wanted to say something. Go ahead.
Are we now on grievances?
Okay, we could start on grievances. Let's do it.
Wait.
Bob is an expert on grievances. give us a wide palette, and then we'll pick and choose some of these topics.
Hey, Steve, Paul Robbins had his hand raised.
Okay, sorry. We'll get you. Bob, I promise we'll get you. Paul Robbins, go right ahead.
Just very basically, I'm also licensed as a peace officer in the state of Texas. Everybody talks about Texas being an at-will state, but if you have a problem with a peace officer, there's a government code 614 that requires fairness for that officer. There has to be a written complaint. They have to receive that written complaint, have the opportunity to respond, and the results of any sanctions have to be the results from that investigation. It seems absolutely incredible to me that we don't have a similar provision in the state bar, one where there has to be a sworn complaint, because when you file a complaint against a police officer, that becomes a public document, and falsifying a public document in the state of Texas is a felony. There are repercussions. Seems like there's very little repercussions for slander against an attorney, even if the slander is by your opposing party in a case. The only other comment I'll make is I find it absolutely incredible that my state bar dues go to pay for an ombudsman for some pro se person or person capable of hiring an attorney to help them file a grievance against me. Now, I want everybody to understand this. I have areas of practice that I'm pretty skilled at. When somebody comes in, I'm very skilled at handling their matter. One of the things I'm not skilled at is defending a grievance, because in almost 25 years, I've never had a grievance against me. So I'm a novice at that. I think my state bar dues ought to pay for an ombudsman to help me respond to a grievance if ever there's a grievance filed against me that I have to respond to. I don't think that's asking too much from my state bar.
Bob, I know you're going to jump on this stuff. Go ahead.
Well, I think we need to look at the procedure that's going on right now. And Larry McDougall, our former president, appointed a task force to look at grievances, and they came up with a report. Some of it I agree with. The biggest issue out of that report dealt with the investigatory hearing, which is an abomination of due process, and hopefully that'll be addressed. But secondly, that report is now in front of a state bar directors committee, Steve, as you know, chaired by Diane St. Ives. And so if there's going to be any change, that state bar directors committee needs to come up with recommendations. Then they need to go to the directors, and then I guess it goes to the Supreme Court. But what's happening right now, all these issues, and what Paul Robbins, who I really don't know, but I love and adore for what he just said, is absolutely correct about the ombudsman, sworn complaints, standard of proof, investigatory hearings that are really violations of basic due process.
Okay.
Thank you.
No, we're not done, but we'll let you jump back in. Well, let's look at each thing at a time. Sworn complaints. I told you how California has it. They don't have sworn complaints, but it's a misdemeanor to make a false one if there's intent. When the bar got this, and a bunch of directors ran on these sworn complaints that they were for that. I mean, I went around and got people to run, and they won. There's several problems. One problem is, and this is what I'm very negative on the bar, is that to get along on the bar, you have to go along. And people who have independent opinions are not thought of. And you look at the last few presidential elections, McDougall they had to take, but you can't discern any policy difference. And so a lot of these people who were campaigning on Sylvia First, on sworn grievances and grievance reform, just forgot it. So when I disagree with you a little bit, Bob. I don't like anything from that committee. And that committee, the chair made a big speech about that we need to protect the public. Well, in my opinion, of course, we need to protect real crooks, but the public's never going to like us. Every person that does a divorce and doesn't get custody, they're not going to say, well, gee, I was a lousy dad. Of course not. They're going to say that lawyer, maybe the judge. So, and somebody says, Steve Gilmore says, unsworn declarations would do the same thing. Yeah, great, Steve. One of the problems with that was they said, what about people in jail? Well, people in jail, if they're going to go into prison, they probably don't care about a perjury charge. But it just seems, if you're going to bring a lawyer through all that hell, then you should swear to what you say is the truth. And we spend so much on grievances that are dismissed, that are not pursued, and a lot of that I think would be fixed if people, we could save a lot of money if people were, had their ducks in a row. This is sworn. I swear that attorney did that. So that's done that. On the investigatory hearings, that's something, maybe we should do a CLE on that, Bob. The problem there is it seems like a good idea. It seems like they say it's non-adversarial. It seems like you're going to get a fair shot. And so I represented a retired judge, and I said, well, what are you going to ask? This case is going on for 5 years. And they write 3 or 4 things. I go, fine. We go in there. The very first question is something totally different about a ridiculous entry that wasn't even important from 2016. And that was like a year ago. I mean, I go, wait a second, this can't be a fishing expedition. And then the other thing they said, the prosecutor, the bar counsel said, you cannot ask questions of the complainant. And I go, you're crazy, and they let me ask a few questions. And then afterwards, remember, one of my problems with the bar grievance system is it isn't uniform. There's no uniformity at all, and George Smith, who I think is a really fair person, goes, hey, Mr. Fisher, can you stick around and tell us what your, critiques? And I told him that, and he says, I don't disagree with that. So you get them, and then you get people who just have to win. They look at it, they get their teeth in it. And I could tell you a case filed against me where they won't give up, to where I had to go to a committee, and the committee looks at them after a few minutes and says, why is he here? So there's a problem. I don't know how to make it uniform. I do know that when they advertise, they talk about 2 years litigation experience or experience in that. Well, why isn't 2 years of criminal law considered just as good? Why isn't 2 years of family law considered just as good? Criminal lawyers and family lawyers get, I think it was 49% of the grievances. This was a couple of years ago. So, it's probably pretty similar. So that's the part on that. Anybody else have an opinion on sworn complaints? When Andrew Tolchin, he's the director, went and he spoke, for the sworn grievances. I don't think that they ended up anyone voted for it except me. But he said that in one of his Facebook groups, we both have a lot of Facebook groups, 495 out of 500 people, 500 lawyers were favored. Now, lawyers are traditionally horrible about methodology and research and stuff, but I think that's somewhat fair representation. Does anybody think anything about sworn grievances? Once again, you guys aren't going to get that much CLE credit.
Steve, I guess the question would be, how would that even come into play? I mean, what is, it's fine to say this would make it better, but if that's what a lot of people are believing, how do we make it happen then? If that's really what we need?
That's yes. Okay. Well, one, every specialty should be equal. If you have 2 years experience, I don't care if it's real estate, I don't care if it's family law, I don't care if it's criminal, you can get those jobs. Okay. So, and that's important because you have insurance defense attorneys, nothing against them, but listening to family law cases that are really different. And, family and criminal clients, my opinion, are often the most difficult. They're extremely upset over what their soon to be ex is doing and fighting over kids. They're not rational and they're demanding. Criminal people, a lot of them know that they might be going to prison. So those.
I just logged on.
Okay. This is somebody that wants to say
No,
something?
that was just, she
Okay.
just came
So
in.
that's one way. I'd like to see, of course I
Well,
do.
see, what I was asking is, how do we make it a rule? So Paul said we should have, a lawyer should have an ombudsman to help them, somebody who's appointed, basically appointed. So how do we make that a rule? Does this organization write a letter to a bar director, or does somebody have to go to a meeting?
Okay, let me jump in. Let me jump in on that. Okay, so let me jump in on that. So first of all, what you need to do is contact State Bar Director Diane St. Ives. She is the committee chairman for the State Bar Directors Committee that's looking at the task force recommendation. So a letter to her saying that we think that sworn affidavits are important. Then we need to put pressure on that committee to vote that out, which then goes to the bar directors, and the bar directors votes on it. And after that, I think it goes to the Grievance Oversight Committee. And after that, it goes to the Texas Supreme Court. Now, I stand corrected if that's not correct. So if that's not right, somebody else jump in.
That is right. Matthew Brown asked me, can I go through those stats again? And my recollection is that 49% of the complaints, now I don't know if it's the final grievances, I'm a little tired, but were for family and criminal law. And I don't know that we're certainly not 49% of the lawyers. We're probably maybe 30% or so. So yeah, and Christine says family law is full of landmines. It sure is. I mean, it really is. People always think that they're the best parent. I just never had anybody say, I lost custody because I'm a lousy dad or I'm a lousy mom. I just never seen that. Matthew, did I answer those stats good enough? I know that a large percentage of things are dismissed. And I also know this, the bar doesn't give these figures anymore, but I also used to do a CLE on how to defend a grievance. When you have a choice between a panel and a district court. Now, if you go to a district court, you can't get a private reprimand, so you lose that. But when I used to look at those statistics, you had so much better chance at going to a district court. I mean, it was more than statistically significant. It was almost twice as good a chance. And so I called a few years ago. I go, how could, you guys just don't give those statistics out anymore? And I don't know if it's because they didn't want the court stuffed up with people going to district court, but I thought that was interesting. And Janine wants the SBOT directors on this CLE chime. Lucy, Andrew, please, Lucy, Andrew, if you guys are here, say something. We got so many people. I thought we'd get about 40 or 50, and one time it looked like we were well over 150. So I can't really tell who's here. I mean,
okay, Steve, let me jump in again. Let me real quickly just jump in that the issue is how do we bring about this change? And every attorney who is on this broadcast and on this site needs to know who your director is. Find out who your director is, write to them and tell them that you are very much in favor of a sworn affidavit, that's the way that we should proceed, and get them to respond to it. The directors themselves, Steve, as you know, rarely get put on the spot by the membership. And this is something we should do.
Yeah, that's a good point. And I hope maybe Lucy will jump in. In a sense, I blame the directors for just going along with whatever the management wants. And so many times I'm on a 29-1 vote. But on the other hand, lawyers have to take some responsibility. If you're not talking to your director, and I think every director is a friendly person, they're open to it. They would listen to you, and talk to them and say, "Hey, I really want this. I think they would appreciate it." So I blame the directors somewhat, but I also blame people for just saying, "I don't know who my director is, and I don't care, and they're not going to listen to me." I think they will. As Ferguson says, criminal law related grievances should be determined by criminal attorneys, family by family law. I agree, except, and I point people to the committees in West Texas, it might be hard. We'd have to have so much extra overhead, I guess, of finding a criminal committee and finding a family committee. But I think the idea is good. Lucy, want to say anything?
Yeah. I have very spotty internet connection. I'm volunteering at my daughter's school.
Okay.
So I've been trying to listen to hear concerns, but my reception is so spotty that and I keep cutting in and out. So that's why I have really bad reception school.
Yeah, it is.
That's okay. You got some bad reception. Just go ahead. Just keep on.
Yeah, sorry. Yeah, I've got really bad reception, so I'm taking a break. Well, I was supposed to be volunteering, but I wanted to hear our colleagues' concerns.
Yeah, and Lucy, by the way, is one of the directors from Harris County, and she ran in a contested race. Lucy, some of it I heard, and most of it I heard. Thanks. And I don't know if Andrew's here, and if he wants to say anything. There's a lot of people that are just here. I can't tell with 150 people. There's a lot of phone numbers here. It's like I know Andrew's phone number, but I'm not going to look for it. Okay. Anything else on the sworn grievances? What about clear and convincing evidence? I don't have the exact numbers, but it looks like a majority of the states say to disbar or to sanction probation, you need clear and convincing evidence. In Texas, you just need a preponderance of the evidence. And to me, that's a little bit scary. You know, what if people believe the public over the lawyer? You're taking away someone's livelihood. You're definitely damaging their reputation. So I think we should go to clear and convincing. And I think that was one of Andrew's ideas way back when we were both doing this in 2012. Does anybody have a problem with that? Or do you think we're putting too much of a burden on the public? And once again, any opinion is just as good as the other. Anybody have opinion on whether it should be clear and convincing or whoops, there's new messages. Okay, and Janine Gorel says, Rich says, what states do not have clear and convincing other than Texas and Maryland? I only think there's one more. I think it's a vast majority. So yeah, Rich, that's a good point.
Steve, so you feel like it should be clear and convincing. When you've brought up that it should be raised, what was the objections that you saw?
Really, I don't want to be negative, but I mean, I felt it was almost like sheep. They made this, Larry appointed this commission, and they just said no, 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 and that it may not be popular, but we must protect the public. Well, that wasn't someone who actually practiced law in the trenches like a lot of us. So they just went around it. I made a friendly amendment because I wanted to salvage something. And I go, Larry, will you accept as a friendly amendment just the sworn complaints? And he didn't. So we had a vote, 29 against, me 4. And that's the way things go. And that's one of my real criticisms of the bar is that. So, go ahead.
I thought that Sylvia put people on the committee.
Okay. I'm sorry.
Because I recommended some people that I really thought would be good for that committee.
Sylvia does put people on the committees, and there's different committees. There's DCAP. But this here committee, no. This here committee was done by Larry. He had that right as president, as when he was bar president. And I don't know, we'll talk about Larry in a minute. But
well, Steve, the main reason for being against clear and convincing is that the Office of Chief Disciplinary Counsel is against it because they want to have statistics, and it's easier for them to have statistics with a lower burden of proof.
I think there's some truth in that. I think at one point, it was about 3 years ago, someone was saying to the bar during sunset, saying, how come more attorneys aren't grieved, and there was probably an explanation for that, but the bar, I think the bar was sort of a little bit sheepish about that. They investigate. I just can't tell sometimes, somebody will get disbarred for embezzling money or almost for not returning emails. If it's their second offense, they'll get a long period of probation. And then other people, this one embezzled $85,000, got a year's probation. Then 1 year later, did it more took money and just never did anything. A little more probation. So I just wish it was when people call me about these cases, and I can't do them now. I just want to know who the prosecutor is and who's the disciplinary counsel, because it's so different, I just wish, I don't know how we can make it uniform. Like they've talked about how the federal guidelines are, but I don't know. And William Wilson says, why must we protect the public? Well, I think we should protect the public. I think the real, if we had sworn grievances and we didn't go after every foolish thing, because a lot of it is foolish, and we went after the crooks and didn't give them a year probation, and you embezzle $85,000, you're done. My opinion again. And so that public that out that 85,000 needs protection. So someone that didn't get emails a lot, lawyers are notorious at taking a long time to respond to emails. So, okay.
Steve, when you say that kind of a sheepish or lemmings type of thing, it's the nature of a quote unquote nonprofit board is such that really and truly it's supposed to be like a mixing bowl where you're doing very little except just voting on things. And so I think it's almost the nature of the structure of how these functions go does, I guess, not support, that's not the right word, but it sort of encourages people not to participate. And it's hard. You're somewhat of a maverick. I'm not a maverick, but I've been called other things. It's very hard to sort of go against that trend. And I guess perhaps one of the questions, and it's really a sub issue, but whether the rules of Robert's Rules of Order, what is done, what is used to run the meetings at the board. Either you or somebody else was talking about that there was an objection made to somebody speaking, that it was off topic or it was not relevant. And I mean, sort of cross-examination rules that we don't have in Texas. So I don't know how that factors in, but the question last year with 2 years between COVID and some of the actions that happened at the state bar, I guess, have they established that they're going to go by Robert's Rules of Order or, do something to facilitate conversation?
They do, but they still have ways of, if you come up with something, to throw it in committee or to say it's not relevant. They don't treat every director the same. I mean, part of the problem is somebody gets elected director and they think, well, I can do what Steve does and disagree every now and then, but they're not going to ask me to run for president. They're not going to put me on good committees. And that's exactly what they do. The bar really, to me, where they're into politics is, we'll talk about Larry, but they make sure that if you're not in line with what they want, you're out. And they do that when they pick their presidential candidates. I don't know why they have to have a nominations committee to go behind closed doors and say, well, we like these two people, when you can't discern between them. They should have people with different points of view. And then to stop independent candidates, it used to be, okay, 5,000 signatures, you can run. compared to the 10 or 12 on that committee. Well, when I got on there, they did what I think is Texas lawyer called, obviously then they don't like me much, the Stop Steve Fischer Act. And they said, well, now we'll take 81016 of the code and make it that you only have 6 months. Well, I believe that's unconstitutional. And I believe that their compelling interest is there's too many people campaigning. That's not a compelling state interest. So they do a lot of that. They rig things. I don't like that we pay for public relations. If we're a mandatory bar, why do we have to spend money on these public relations offers? We're not supposed to be, that doesn't help with the legislature. And they come back and they're supposed to print every article that pertains to the bar. And so I write 5 columns about, about free speech, and different papers publish them. And they go, we're not publishing them. I go, why not? It came out on the Google thing. Well, we don't agree with that. You're wrong. There's so much of that. And I think when this gets remanded, if the bar doesn't change it 180%, they're going to get nailed. And that's my opinion on that. So, the next thing I want to talk about is Zoom. And here's something where I personally believe that a lot of times the bar directors are just not connected to the public. I mean, they're not going to be like me where I stand in front of courthouses and ask, hey, are you a lawyer? And talk to them. But still, they're just not connected. And one of the best examples was I was out at the Fort Worth at Tarrant County getting signatures, to run for something. I mean, it was when I was bar president, and people were saying FY to the bar, and I don't care about the bar. I hate the bar, and you're not going to do anything. And my wife's there, and we're just going, oh my God, it was one of the first times we get signatures. And the last person, and there was a bar meeting starting at 10, 5 blocks away. And so the last person, this lady comes up to my wife and she goes, I want every single bar director and officer to be boiled in hot oil until they're dead, except your husband. And, we're just reeling. So we walk over the 5 blocks to the bar thing, and Buck Files was the president. And he sees me, he goes, oh, Steve, here's my friend Steve. And I want you to know, and my friend may disagree, that that's the quote, all attorneys in Texas love the bar. And so they're so disconnected, in my opinion, that I don't know. I think there's something about, circling the wagons. A lot of people don't like the bar. I would say a majority of lawyers. And so we give each other awards. I hate that. I usually leave the meeting when they do that, just plenty of awards, and tell each other how wonderful we are. And we don't really do anything. And part of that is because lawyers just don't get that involved. But, it's come to where I've asked them at the last meeting, let's talk about either other bars or other things besides opening things up, making it better for free speech. And they don't want it. They're just going to have this committee. They can make sure I'm not on it, which is fine. And they're going to do whatever they can legally to thwart that decision, in my opinion. I'm certainly not going to talk anything about what they do in closed door session. Okay, Zoom is something that I think the bar should be involved in. There's a task force. Justice Tracy Christopher's in charge. They want our input. So again and again, I try to get it on the agenda. Once again, this is my opinion. Zoom should be available. Who is they making policy? It's the staff. It's the chair, the past chair, the president, the past president. And I think that when lawyers have a non-contested hearing or a non-witness hearing, if they agree that lawyers should have the right to have Zoom, in places like I think it was Ruben from this group who's telling me, you have to drive a whole bunch to go to a court appearance. It takes 5 minutes. It costs money. It costs gas. I think Ruben was saying sometimes he doesn't get back till after lunch. And what for? it's not that I don't like going to courthouses. I'm a social animal, and I look and these are my friends, and I love to walk around after court and look on the other floors. So what, we still get that. We still have contested hearings. We still have trials. But please let attorneys have some say. And I know attorneys are in favor of that. And maybe they're not. And I'd like to ask people's opinion on Zoom. But the bar wouldn't put it on the agenda, finally put it on the agenda, and they didn't want to talk about anything besides congratulating Justice Christopher, and David Sergi, the director, is supposed to rewrite that. But what do you guys out there think about Zoom? And look, even though we have a huge group and still like 140 people, somebody has an opinion on Zoom. So anybody?
Can I say something?
Sure.
Definitely, Earl.
How you doing? Thanks, Earl Spielman, Houston, Texas. Zoom is really good for me because I'm handicapped, and for me to be able to participate and earn a living, Zoom has just been wonderful. I have an impaired system, and the last thing in the world I want to do in this day and age of COVID is go to courts and get God knows what. You know, it's very hard for me to get around. I'm recovering. I'm doing well. You know, yay! I'm gonna be okay. But getting back to Zoom, thanks. Getting back to Zoom, it's a godsend. It's something that we can all use. We can actually bring our clients into it, especially for us in the municipal bar group. You know, we can bring our clients to court, so to speak, on Zoom, and we can get everything done that we need to get done. And as far as in the criminal arena, which is what I do a lot of, it's a fantastic thing. And then the civil side, which I also do practice in, it's very good because you can have access to a judge very easily. This is a real good way to clear a court's docket. And you're right, Zoom is really, really good. There are a few other things that are out there that are similar to Zoom, but Zoom is the easiest one to use, and everybody can master it in a matter of 5 minutes. And so I agree with Steve Fischer. I think that this is something that all of the attorneys should have available to them. It's not expensive, and we should get something for our money, because we're not getting anything for our money from the State Bar. I can't stand the State Bar. I'll shut up now. Thanks for the opportunity to talk.
Wait a minute. I thought that Steve just said everybody loves the State Bar.
No, you know he doesn't.
Yeah,
You're funny. Okay.
No, okay, thanks, Earl. And when I'm
Christine, did you have something to say?
Pizza when I'm in Houston. Okay.
Yeah, this is Christine Mangle from Galveston County. Hi, Steve. Good to see you again. I do a lot of CPS work, and it's been a godsend for us in terms of CPS. We've actually done it since March of 2020. We started right away. And it's allowed us to, keep the statutorily, the guideline hearings that we have to have. Unfortunately, trial-wise, we're so backlogged. I don't think that a trial to terminate parental rights by Zoom is the way to go. But for our at least statutory hearings, we've had a good outcome with those. We've had parents that a lot of times don't show up to court actually be able to come to court via, electronically. So I like it.
Yeah, and I want to make clear, because a few people are commenting, we don't necessarily want it for cases with lots of evidence. We don't necessarily want it for cases with lots of witnesses. What I'm thinking about is in certain areas of law, it's a cattle call. You go to the courthouse, you find parking, you go there, and the judge says, are you ready for trial? And you say yes or no, and they go, okay, December 15th, why do we need to do that? It's bad for the environment. It costs gas, it costs time, it costs dry cleaning, because I don't have to wear a whole suit when I'm on Zoom. So yeah, that's what we want. We want attorneys to have to say. Why doesn't the bar fight for us and say, hey, let attorneys do it? Justice Christopher, chair of that committee, wanted so much for us to give her the input, and the bar sort of killed it. Maybe David Sergi can get this back on there. So that's how
Steve, let me interrupt one other thing on this same point. All of us have to go through the Board of Law Examiners. Every attorney becomes an attorney has to go through the Board of Law Examiners. The Board of Law Examiners was doing informal settlement hearings on Zoom, And then they decided in September, we're not going to do that. We're going to have everybody come to Austin. Now that may change with the COVID, Delta COVID, but there's another example of the bar not doing anything about the Board of Law Examiners saying we're going to do away with Zoom hearings. I mean, that would have been something that the bar could have done.
Yeah, I mean, you know what? Behind closed doors, I just begged some of those directors. I said, let's put this on there. And you know why? There's public relations, and but I said, let's show attorneys that we're thinking the same thing they are, because wherever I go, it's people like Zoom. And I see the comments that they like the courthouse. Like I said, I love going to the courthouse. I'll finish a case and walk on the other floors. Doesn't matter what county I'm in. And I love to see my friends. And of course, some of us do cases all over the state, and I'm one of them. And sometimes I'm in Washington State. I really like not having to fly to Houston, and I have cases in Corpus and Rockport, even though I'm in El Paso. Without Zoom, I couldn't take a lot of those cases. Okay, any more on Zoom? I'm going to get to something. I want to play a little bit part of the court's opinion, some of the oral argument. Anything else? We got 15 minutes. I'm hoping Larry.
Paul wants to say something.
Sure. Go
Steve,
ahead.
I came here to listen, not to talk, but I'll try to make this the last time I comment.
Talk as much as you want.
Well, I'm a trial attorney. That's what I do. There's some things that are very conducive to Zoom that I think we're absolutely shocked that us dinosaurs in the legal profession are the last ones to catch on to the rest of the business world. But in the same sense, as a trial attorney, I believe my effectiveness, and people hire me for my effectiveness in the courtroom, and that's severely diminished in evidentiary hearings with witnesses on the stand. It's just not the same looking into a box and talking to you fine folks or trying a case that way. We shouldn't say a one size fits all. We ought to look at it, and the state bar ought to perpetuate a system that allows for most efficiency. One of the things you touched on earlier, Steve, and you and I agree on it, although we're diabolically opposed on many political things and other things, I respect you and I think you've got good ideas, and I support you strongly as I did Larry. But this is a access to justice issue. I can more feasibly bring somebody to my office, set them here in my law library, and have a Zoom hearing, and I can get through those quite effectively. I work with different agencies, and I'm a regional attorney for Texas Municipal Police Association, which means my region runs from Texarkana to Beaumont and west of I-45. So I can literally spend most of my waking hours driving from one issue to the other, or I could certainly come to my office and get on a Zoom hearing for something that's administrative, something that's simple, and we ought to be making effective use of technology, like telephones, like Zoom calls, and like the rest of the world has been doing. But I do think that evidentiary and final hearings before a court in a court system provides a dignity to the process, a dignity that the public respects and understands. And I don't think it's a one size fit all. I think I can argue a motion for summary judgment, or I can have a dispute over a discovery issue, or I can have a status hearing, whether it's in federal court, which I've done by telephone, whether it's the State Office of Administrative Hearings, or whether it's in any court in the state of Texas by the way of Zoom. But I do believe that we need to be rational. The state bar needs to help us with efficiency, and we need to have the option of being in the courtroom when it's strategic and it's necessary to be in the courtroom, and use the efficiency of technology like Zoom as it's available and when it's appropriate.
Good. No, I really appreciate it. If it wasn't for
Judge Deidre Davis?
Yes, sir. Yes, sir. I'm currently before the Texas Supreme Court, so I'll have to keep my statements at a minimum. And I'm before the Texas Supreme Court on the topic of virtual jury trials. But I would like to just sit this little tidbit here. As the judge, when I'm in the courtroom and there's a witness on the stand, I'm staring at the back of their head for the majority of their testimony. And every now and then they turn toward me And when they turn toward me, then the jury is staring at the back of their head. And that goes on for the entire time. However, when the witness is on Zoom, I'm looking them right in the face. I'm seeing all their expressions. I know how to work Zoom where I make them the spotlight and I see everything. And so I did want to just sit that there. It is different, but I'm a judge who's done over 50 trials on Zoom. So that I do have a comfort level more than the lawyer who hasn't had one or two maybe things on Zoom. So I understand I'm more comfortable with Zoom. But for me as a jurist, it's different, but it's so much more effective for me. I'm able to have them right there. And the jurors, they see them right there. They never see the back of their head. They don't see the side of their head. They have them right there in the face. That's all I wanted to say. I really can't say anything more. And thank you for the opportunity to speak.
Okay. I think, and you know what? No matter how many hours we schedule this, it looks like it could go over, and I'll stay and until people get tired. I want to play something from.
Hey, Steve, I'm here.
Huh?
Go ahead, Larry.
Larry, great. Larry Senior is Larry McDougall. Larry Junior is Little Larry, if I get these things right. Okay. One of the things that came up in this opinion, and one of the things I think is going to dog the bar and really cause trouble, is free speech. And I know that I took a lot of hell, no word less than that, for defending Larry's free speech, even though I don't agree with you, Larry, on a lot of things. But I want you to listen to this because the bar's spinning and they're not going to say anything about it. And it's only a minute from the Court of Appeals, and I'm going to start at 4340 in case you want to listen.
We have a bar journal. We have letters to the editor in the bar journal, but we have a clear statement in the bar journal. It says these are not the position of the bar or its members.
Now, just as Robert, that is the bar council.
And I think that's an important distinction. So when we talk about
what about efforts by state bar directors to censure or limit the powers of the state bar president because of political or ideological statements, right or wrong, that he has made? There's nothing theoretical about that. That's actual action being proposed by state bar members of the board of directors, withdrawn only because of the public statement of one of them. The legal counsel said this one might get you in trouble. You better not do it.
Well, that happened after the summary judgment record that was in front of Judge Yackel. And so I will talk just generally on the issue that I think that.
Well, it's all on your website. We can take judicial notice of all or most of it, and exactly what happened, and there's little dispute about the facts. So why don't you address it straight on?
Yeah, I mean, I think that the bar has a right to have a discourse about what the right thing for its president to say and not say is, and it's not it's no different than an internal, in my view, an internal discourse on what's appropriate for the conduct of a bar.
Once again, my opinion, it doesn't get any better for the bar. This guy's just stumbling through all this, and it's a very divisive issue. My son, Ray Fischer, he's starting with Jackson Walker in San Antonio next month. He called me and said, "Larry, and you ought to resign." What did I do wrong? I brought him to court when he was little. I got him rabbits and possums and stuff. But it's a really divisive issue. But I knew the case that I brought up, and bar counsel did too, I guess, but I did it first, is Wilson versus Houston Community College. I knew that Larry had a super lawsuit against the bar, and we already almost know who was going to do it. And if you love the bar, if you like the bar, if you just want the bar to survive, and I went overboard. I admit it. I was in a rage, but the witch hunt against Larry, even though I do not agree with a lot of his conservative ideas, he still gets the right to say them. And he gets the right to say them in 2015, way before he ran for bar president. But the bar's going to get nailed on free speech. And it's going to get nailed when this gets remanded, because I can give you so many instances of the bar just no way, whether it's having armed guards remove me from the CLE that I paid for because during breaks, I was very quietly getting signatures or whatever, or changing the rules to make it hard for independents. The bar is not good on free speech. And it's one of my biggest criticisms of them. I think they do a lot of things good. And I think they're going to pay for that. I think that's going to, please, I know a lot of you disagree with me. So feel free to say that and you'll get your turn. What is, okay, hey, Larry, are you there? I would love to hear what Larry has to say about what Firth said about him. I don't want to get too much into personalities, and I don't even know exactly what you're referring to. I know that sort of Larry it seemed like he was badgered into not being as strong as he was, and his health issues. Larry, talk to us for a little bit.
What are you talking about that Firth said? What are you talking about there, Steve?
What? I'm
you
sorry.
Said Firth made a statement.
It
What are you
said the
talking about?
Oh, no, it looks like
chat.
Oh, the
I
fifth.
don't know the answer to that. Bob,
Steve, you said the wrong court. That's all. That's why Larry got.
said it. Okay. What do you think about what you just heard, Larry?
Well, Steve, the way I responded to it was
Larry, you're breaking up really bad. Larry, you there?
Do everything that I could do that I intended to do. And I just went back to now I can't even hear them.
That's all right. You don't need to hear us. You tell us. Go ahead and say.
Well, I will tell you that the Supreme Court the Fifth Circuit just backed up the Wilson case, and we know that Wilson case is going up to the Supreme Court, and I fully expect it, at least I would think, with the current makeup, that it's going to be affirmed, if not strengthened, by that. I mean, I really don't want to get into a lot of the McDonald case because we're still in litigation on that. But, Steve, there's no question that members of the bar, including staff members, tried to basically silence me and every conservative on the bar. And I think that was the intent and the purpose of it, was to silence us and no diversity of thought. And that's what they were trying to do. So on the First Amendment agreement there, I do agree with you. But as far as really getting into the heart of the case, the McDonald case, we're still in litigation. We got a long way to go. And on that, I'm just going to kind of keep my thoughts to myself like I did during that July 27th incident.
Yeah, no, I get that. And yeah, I'm sad to see that they did pretty much silence you. And I think the purpose was, I don't think they cared about your statement. Any Republican congressman would say the same thing, as much as, especially considering it was 5 years before you took office, or 4 years. It's that they used it to kill bar reform and to render you somewhat ineffective. They'll never silence me, but you and I we're good friends, different personalities. Anything else that people want to bring up? It looks like we're about to go.
Well, Steve, I'll just put it this way. You and I seem to have the same goals and objectives. We just take different routes of getting there. And I think we did accomplish a lot this past year at the bar. I mean, just by putting our heads to the grind and going and working. I mean, we've got now grievance reforms before DCAP. That's never happened before. And we got that going. We got the changes to the ad review. I mean, a lot of things were accomplished without getting up there and getting in these ideological debates and just letting them say what they had to say and move forward. And that's what we did. And we did accomplish a lot, but there's still a lot to be done.
Right. Okay. Hey, Larry, Tasso, who's attending this from Greece on vacation, wants to know, how did the bar try to silence conservatives? Do you have an answer for that?
Well, look at what they did to me on July 27th.
Oh, I mean, I wanted you, he was asking you, so I wanted your answer. And I'm not a conservative.
I'm not shying away from the fact that you want to call them the wokes, whatever you want to call them, they came after me. And their goal was to silence me. They intentionally, I mean, you know, Alistair Dawson filed that motion, so I couldn't speak on behalf of the bar anymore and tried to push it. I mean, they really tried to shut me down, and along with me, every other conservative that was on the board of directors.
Well, I'm not a conservative, and they shut me down. But hey, we killed that Dawson thing by and this isn't in the bar minutes, but I made that not so friendly amendment that anybody who votes for this reimburse the bar for all the legal fees that we're going to get in the resulting suit. And Chad Baruch goes, "You pissed me off all meeting," but that was genius. That was hilarious. So that's how we kill that. But anything else now? Look, we'll just whoops, what's going on? You didn't. Okay, oh, there's the course number. See it there?
I'm just sharing the course number for the remainder so that if in case anybody wants to see it.
We've done our hour and a half. Is there anybody who wants to speak and about any of these topics? I will stay here. You know, if we make it an hour and a half, people will stay an hour and 40 minutes. We make it an hour. I've learned this, you know, but if we go long enough, once the state bar very nicely said, you know, your lecture went 30 minutes extra, we're going to give everybody 30 minutes more credit, which is, once again, I really like the CLE.
Did you talk about I'm sorry, but did you talk about the lawsuit?
The what? Are you talking to me or are you talking to
Yes, I'm sorry, Brian Samuelson. I mean, the title of this course, if I recall, was, I mean, I'm not picking on you, but I just thought we were going to talk about the how that lawsuit affects us.
Well, I thought we did, and let's
yeah, it's a long lawsuit. I just got through reading most of it, so we touched on a lot of it. So, but anyway, yeah. Reuben, can you? A lot of people don't get into chat, or don't even know how to, or look at it. Can you give out the case number, the course number?
It's a 174-131-614. Yeah. No, I think we got through this in the beginning about.
I want to ask one more question. I'm sorry.
Sure, go ahead.
Can I please ask, how does that lawsuit affect all of us?
It won't, because it's not final. It's going to be remanded. So that's why we're talking about free speech and dues and whether they're going to be mandatory and what dues, because as you see in the last thing, it's remanded to see what relief the plaintiffs get. So Steve, I'm trying to give you a framework.
Steve, I think Brian wants you to just read what you were about to read, but you got kind of diverted from the actual opinion. You were about to start from 46 something or other. I don't remember. That's what I think he's asking.
No, he read that. Steve read that. Steve read that. Okay, it's been read. The point of everybody listening to this program is to take it upon yourself to read the opinion and then form your opinion and write to the state bar director, who's the director for your area. If you want to have some impact on what's going on with McDonald, that would be the best way to do it, but read it yourself.
Well, I want to give him a more answer. I mean, when they say
if there's a page that you would like to talk on, I can share the screen.
Page 34, and it's the very bottom. And you're right, I read it, but you know, people take breaks, they don't listen to everything. blame anybody. We vacate the summary judgment, render partial summary judgment in favor of the plaintiffs, and remand. There we go. It looks like and remand the court to determine the full scope of reliefs to which plaintiffs are entitled. So once again, we have an expert on here. Okay, and Scott Rothenberg says, and Scott Rothenberg is an appellate expert. If they file a petition for certiorari, right? Okay, if they file cert, now Scott, unmute Scott and stuff. I'm understanding that it's something the Supreme Court will not really want, a case that they're not excited about because it just affects lawyers. You might want to explain that if you want. It doesn't matter that we're overtime. So I think it's going to go back and remand it and they're going to have a trial. But you know what? I certainly defer to Scott Rothenberg on that. Scott, are you there? No, I guess not. Okay. All right.
Well, Steve, Bob Bennett, isn't the real issue is whether or not a class action is going to be filed or not, either in Travis County or somewhere else, to make more members of the bar be in the same position as the plaintiffs were originally?
Well, I don't like to go on rumor. I've heard that there's going to be a class action. These things cost the bar a good sum of money, and I don't want to speculate on it until it's filed and I see it. And hopefully the Associated Press will do a fair story. Texas lawyer, in my opinion.
Is there anyone, may I ask a question, please?
Sure, wherever you are.
This is Rich Robbins. Is there anyone here who would like to get their dues refunded?
I don't know that you can get them refunded yet, Rich, but okay. I think you posted that they can write to you, and that's fine, you know. And you do have an informative website. Obviously, I don't agree with everything. I don't think you should rack the bar for the Tasso says we need a group that will look over the bar. Well, you know, I wish we could have one, but we don't. Okay.
Hey,
Anything
Steve,
more?
The Watchman?
Go ahead.
May I say my email address? I haven't said it over the phone. Just I typed it, and not everybody sees chat. My email address, if anyone is interested in pursuing a return of previously paid dues, is rich@texasbarsunset.com. That's rich@texasbarsunset.com. Thank you very much, Steve, for this great presentation.
You better not be getting money from me.
Steve, Alex Wathan here. I have another comment here about the Louisiana case, the Boudreaux. The Fifth Circuit said that simply failing to itemize where the money goes to so that somebody can object and get a refund, that alone is a cause of action that pleads a sufficient cause of action. So I think do you believe that we're going to have a checkbox system just like we have with the bar sections?
I don't know. First of all, our bar is a lot bigger than Louisiana. I've looked at that budget. It's hard. And, you know, they say that the bar should have a way, I mean, in that opinion, that someone can go and protest the bar. What the bar does is they let you speak in the public sector if you're just an average attorney, and they don't answer you, of course, just like when I was on a school board many years ago. And so you don't really get the chance to speak to an agenda item and get feedback. And I so wish the bar would let that, you know, I believe every attorney is equal. And, you know, Paul or any of these people make such good points that the bar should just let them have it. When the agenda item is Zoom, let people talk about Zoom. And the bar should say, here's what we think. You're wrong about this. This is what we can do. I mean, I really I wish the bar cared more about our opinions. I'm saying our, not as, well, they don't care about my opinion as director either, but just as an average attorney. So we don't have that. And it's amazingly distressing that lawyers at the bar, and that lawyers shouldn't be reticent. They should speak out, and the bar doesn't seem to care. I know I've defended the bar a lot today. Some things they're great at, some things they're horrible. Anyone else?
Okay, so what I'm gonna do is I'm gonna wrap it up right there. We're gonna